back to Roe v. Wade versus Dobbs v. Jackson. I'm Kaylee.
And I'm Sydney, and I'm not gonna lie, it's been quite a ride. Over the past 4 episodes, we've unpacked the legal, cultural, and personal impact of 2 of the most pivotal Supreme Court cases in American history.
And today, in our final episode, we're zeroing in on the legal arguments presented by Jackson Women's Health Organization, the last remaining abortion clinic in Mississippi at the time of this case.
If you've been following along, you know that Dobbs v. Jackson Women's Health Organization was the 2022 case that ultimately overturned Roe v. Wade and Planned Parenthood v. Casey. It didn't outlaw abortion nationwide, but it did remove federal constitutional protection, handing power back to the states.
Which has led to a pretty messy situation. Basically a patchwork of laws where your rights can totally change depending on what state you're in.
Exactly. And in today's episode, we want to zoom in on the Jackson Women's Health side of the argument, because their legal strategy was grounded in some of the Constitution's most foundational principles: liberty, privacy, and bodily autonomy. Before we break that down, let's bring back Mr. Cooper for one more setup.
Why do you feel that Jackson Women's Health Organization took this case to the Supreme Court?
Well, certainly the 6-week ban and other bans were how do I say this? Under Casey, it would be unconstitutional. So Women's Health Clinic had a choice. They could go before a potentially hostile Supreme Court and probably lose, or they could not challenge the law and definitely lose. So a small chance of success certainly motivates somebody to, as opposed to doing nothing. The other thing is that it's a little bit like copyright. If you don't challenge things you think are against the law, you might lose the ability to challenge them. Certainly, for example, if the 6-week ban had been ignored in Mississippi and not been challenged, and then all of a sudden 5 other states pop up with one, you could look back and say, well, wait, why didn't anybody challenge what was going on in Mississippi? And that's a valid argument.
So their legal team built their argument on the 14th Amendment, specifically the Due Process Clause, the same clause that helped establish the right to privacy in Roe. The idea is that the due process isn't just about fair legal procedures, it also protects substantive rights, like the ability to make deeply personal decisions about your own body.
So basically, you can't separate fairness from freedom. If the state is interfering with your most personal choices, that's not just unfair, it's unconstitutional.
Exactly. One of the central themes of this case was bodily autonomy. They argued that forcing a woman to remain pregnant against her will directly violates that autonomy and undermines liberty itself.
And that's not a new argument either. It has legal roots going back decades, right?
Yep. Since Griswold v. Connecticut in 1965, the Supreme Court had recognized a right to privacy in matters like contraception, family planning, and personal health decisions. Jackson's Women's Health framed abortion access as part of that same constitutional tradition.
It wasn't just about abortion, it was about what else might be at risk if those protections start unraveling.
Exactly. And another major argument was around the concept of undue burden. That came from Planned Parenthood v. Casey in 1992, which said that any law placing a substantial obstacle in the path of a woman seeking abortion before viability was unconstitutional.
And since Mississippi's ban started at 15 weeks, well before fetal viability, it clearly crossed that line.
That was the argument at the time, especially considering Mississippi already had very limited access to abortion. For many women, Jackson's Women's Health was their only option in the entire state.
Which is wild. One clinic for a whole state?
Yep, and that brings us to the Gestational Age Act, the only law at the heart of this case. Passed in 2018, it banned abortions after 15 weeks, with very limited exceptions. Only for medical emergencies or severe fetal abnormalities.
No exceptions for rape or incest, as we covered in last episode. That's a lot to take in.
It was challenged immediately, and a lower federal court struck it down as unconstitutional. But Mississippi appealed all the way to the Supreme Court. And what makes Dobbs so significant is that Mississippi wasn't just asking to uphold the 15-week ban, They were asking the Supreme Court to overturn Roe and Casey entirely.
And the court said yes?
Yes, they did. In a 6-3 decision to uphold Mississippi's law and a 5-4 vote to overturn Roe, and that changed everything.
If you were to look at it from a pro-life perspective, what Constitution principles were at stake in the Dobbs case?
Ooh, that's an excellent case. A lot of it comes down to a difference in opinion about how strictly you read the Constitution. And that is a hard question. Even Anton Scalia was not, as he would famously say, a strict constructionist, which is a fancy way of saying the Constitution only covers the things that are written in it and nothing else. That's not what anybody thinks, really, even conservatives or even liberals. It's just sort of like, no. But as we go forward in time and we have new technologies and we have different ways of looking things, you have to decide, okay, does the Constitution apply to this circumstance? Certainly Dobbs's, the attempt to overturn Roe v. Wade did have a values-based component. It was a matter of, look, we really don't think abortion should be legal in most or all circumstances. But from a legal, academic point of view, it's like there's a certain movement that says we should not invent rights that are not specifically listed in the Constitution. Arguing about what a freedom of speech entails is worth it because there is a specific freedom of speech written into the Constitution. The flip side of that, though, is that the Ninth Amendment is very, very clearly a non-specific amendment. It says I'm misquoting it, but it says the rights of the people, other rights of the people, that are retained beyond the ones that are expressed in this Constitution. So literally the Bill of Rights does include this, no, but wait, just because we didn't list it doesn't mean it's not there. And so I think that undermines that legal argument, but I'm sure lots of people smarter than me would disagree.
From that side, the argument was rooted in states' rights and more originalist view of the Constitution. Many pro-life advocates believed Roe was wrongly decided, that the Constitution never mentioned abortion, and therefore it should be up to elected officials in each state to decide.
It really came down to this clash. Who gets to make the decision, the courts or the people?
Exactly, and the fallout was immediate. Within days of the Dobbs ruling, trigger laws went into effect in more than a dozen states, banning most or all abortions in them.
But at the same time, states like California, New York, and Illinois passed new protections and even started offering abortion access to people traveling from out of state.
The legal landscape was fractured. It created what some call abortion havens and abortion deserts. And for Jackson Women's Health, the clinic at the center of it all, the decision was devastating. They had to shut their doors shortly after this ruling.
That's heartbreaking. All that history and all that work gone in an instant.
The clinic's director, Shannon Brewer, relocated services to New Mexico, a state that still allows abortion access. This shift showed how geography is now a bigger factor than ever in determining reproductive rights for women in the United States.
Whether or not you can get care shouldn't depend on your zip code.
It's a question many are still grappling with. And to help us close out our series, we asked Mr. Cooper one last time to leave us with a few words of reflection.
What would you say to individuals who view Dobbs as a setback for women's rights?
I think that's an understandable position. The Supreme Court, by its nature, is largely insulated from the political process. So while I am absolutely convinced, even if you're looking at fairly conservative places like Texas and Ohio and Kansas, not Texas, sorry, I meant Kansas and Ohio as my two examples, where these are fairly solid red states that have passed constitutional amendments to the state constitution which preserve the right to an abortion. So I think that somebody who's looking at Dobbs v. Jackson really will see this as a setback because they do have a majority in terms of public opinion, at least in general, depending on how you phrase the question. But here's this other, here's the Supreme Court coming in and saying, it doesn't really matter. But the flip side of that, and this is the hard part, it's now a state's issue. And part of the reason I think politically this hasn't blown up as big as some people thought it would is the vast majority of citizens of the United States live in states where the process is still legal. And that means if you are, for example, living in Idaho, you got in two neighboring states where you can take a drive, get health care, and then go back home. And as a matter of fact, where this is going to get real interesting in the near future, a lot of those states have started passing laws forbidding interstate travel or assisting in interstate travel for the purposes of taking, getting an abortion. And that's going to be a really hard case for the Supreme Court to take, because that is definitely a new interpretation of what interstate commerce might be regulating. And that means if it's interstate commerce, that's a federal government decision, not a state decision.
So as we wrap up this 5-part series, let's take a moment to reflect. We've looked at Roe, Casey, and now Dobbs. We've explored legal reasoning, the makeup of the court, and how these rulings affect people's lives.
And it's not just about laws, it's about autonomy, healthcare, power, and who gets to define what freedom looks like in America.
So whether you agree with the decisions or not, there's no denying that they have reshaped the country.
And this story isn't over. Lawsuits are still being filed. State constitutions are being amended. Ballot measures are coming in the future years.
We hope that this series has given you more than just legal facts. We hope it's made you think. These cases are more than history. They're ongoing and ever-changing.
Thanks for coming along with us. From the foundation of Roe to the fallout of Dobbs, this legal journey is far from over.
I'm Sydney.
And I'm Kaylee. Stay curious, stay informed, and keep asking questions.